Hi friends from around the world, from Nigeria, India and Argentina in particular. We will talk about the inter partes proceedings today. Inter partes meaning that beside you, yourself, the design holder, and the EU IPO, there's a third party intervening in the proceedings. So it is one against the other rather than one against the EU IPO. So it can be in one way or the other. So it may be that you look for entertainment, just for entertainment, the publication of the IPO on designs, and you see a design which is, wow, this is just my design, how can this happen? Or on the contrary, you are a design holder and you receive a invalidity request from a third party, from somebody from around the world, requested to EU IPO and sent to you in copy. So this may concern you, and there is some information which may concern you even more, but on the other hand, the invalidity requests are not as often as, for example, opposition and trademarks, which is roughly 1/5. Here we have much less. I cannot provide you some concrete statistics, but I know there are much less examiners dealing with design invalidity requests than with oppositions. So this is quite okay. I will give you also some other information on the general proceedings, which may make you more quiet, which is about the right to be heard. So anything which is opposed to you or supposedly opposed to you in a decision or in a future decision, you have the right to be heard to that remark. So that is an important issue. Nothing can be held against you if it is not known to you and you don't have the possibility to argue on it. This is one thing, and the equality of rights between the parties, so one party and the other party, EU IPO in the middle, each information which comes from one party to EU IPO will necessarily find its way to the other party. So everybody knows everything on what is the subject matter, and EU IPO cannot base its decision on things which are not known to the party. Unless it is law, right? That's clear. So if the parties don't know the law, there is nothing we can do about. Now let's have a look at 25 CDR, Community Design Regulation, which is the basis of, and here it is on the screen, which is the basis for the invalidity claims by a third party. You may want to read it with ease. I will not go much into details of all the different grounds I highlighted here. In my opinion, most important ones, that would be Article 25, 1D, E and F, Community Design Regulations. All of these are relative grounds, so these three, based on earlier rights. Anybody can also file an invalidity request based on absolute grounds. So alleging, for example, that the contested sign is not a design properly in the sense of the Community Design Regulation or lacks itself individual character. So let us dive a bit, if you want, a bit deeper on the three relative grounds I highlighted here. The legal language often does not pass very well with business people, and that would be rightly so. I will go a bit into the matter. Article 25, 1D, which is the most important one and the one I have stressed multiple times already. An early design or design patent, if we call it often, you got it already, and you know that this design must have an earlier filing date or priority date if that applies, and it must be disclosed. The best case would be a registered design. We already discussed it, and I will not insist on that one. Now we have 25(1)(e) that refers to a distinctive sign, so not necessarily a design, used in a later sign, so the contested design registration. Additionally, community law or member state law governing this sign must confer, so this earlier sign, must confer the sign the right for an invalidity claim against the design registration. So this clause alone does not tell you the whole story. In order to understand the scope of the clause, you need to know more. What are the member states' signs which confer the same rights? And here we are. That's quite a lot. From the EU point of view, community designs, registered or non-registered, and EU trademarks confer this right. Member states' trademarks and designs also confer this right. So it may be registered or not registered trademarks. Designs naturally. And now we're talking already about, well, some kind of millions of earlier signs which have to be considered as potential basis for invalidity claims. You have to understand this. In this case, in the case discussed in the previous video, I referred to a US patent. I think, to be clear, it was a design patent, evidently not an invention patent, because invention patents are not signs and cannot be the basis of an invalidity claim. So, and finally we come to 25(1)(e). We are not done yet. Copyright also enters into the mix. As you know, copyright is not an EU right. The corresponding competency has not been transferred to the EU but remained with the member states. So national copyrights, earlier ones only, naturally, can also constitute a basis of invalidity. On top of them, many of them are not registered in the EU, naturally is not possible, and in the member states either. So the due diligence you will make will, so to say, never be complete. Now, let's look at the grounds you have here. The invalidity applicant is not limited to one ground only. He can raise as many grounds as he wants in order to be successful in the invalidity application. So you have to take this into account. And then we have general principles, which I already pointed out to you, which is, so to say, the rule of law, the right to be heard, the equality of treatment of the parties. Now, there are some, so to say, due to experience you have seen in the boards of appeal, there are some tactics we have seen over time. So three tactics you may distinguish between one and the other. The first would be you put a whole lot of earlier signs into the mix, knowingly that not all of them have the same strength, are same convincingly in order to go through, so to say, to be successful for the invalidity request, but in the hope that the examiner will be somehow lazy and will not go over all of them. They do not want to make the case, and they will just, you take the first and I will go through and I don't know anything else. So this is not really the case. The examiner, there is a kind of economy of proceedings, and I will walk you through these cases. So if you have many earlier grounds, the examiner will look at all of them and will choose, so to say, the strongest ground. And the strongest ground from the earlier sign or design would be X, Y, and Z, and would walk through this ground. And if this ground does not hold water, then at the end it will say, well, this is the strongest case for the invalidity applicant. It doesn't hold water, so I do not go into the remaining earlier grounds which are weaker. So the same would apply, for example, if you have 4 different signs, or 5 or 10 or 20 different signs on which you base your invalidity application, also in the hope that you will overwhelm the examiner and he will just give in order not to go all through these trademarks or whatever it is, designs or signs or whatever it is. So again, economy of proceedings, you will see at the end they will choose the strongest sign and the strongest sign only, or if the sign is strong on its substance but not on the disclosure, etc., it will kill the second strongest, probably on disclosure or on its weak point if it has. Naturally, if it has not, that is still okay. But again, you will not overwhelm the examiner with this, or the boards of appeal if you want, because they will choose a way out, so to say, a go around over that tactics displayed by you. So what does that mean now for the the same thing if you have in the proceedings you may have not one party making an invalidity request. You may have 5 or 6 parties doing at the same time invalidity request against your design registration. So again, they do not need to go through all of them. They would just choose the strongest one, the strongest case of the invalidity applicant, of one of those invalidity applicants, and would go through this and would say, well, this goes through. Okay, I do not need to look at the others because the design is already killed, so to say. Or the other way around, if the strongest sign is not able to kill the sign, so the others, they are a fortiori not able to kill that sign. And what does it mean? So for you, the design holder, so from the invalidity applicant is clear, you should be strong, you are well advised, so to say, to focus on your strongest sign or on your strongest ground and argument around that. And from the design holder, well, same thing. If you know from beforehand the examiner will focus on the strongest sign, on the strongest ground, or on the strongest invalidity applicant, then you should focus your defense just on that. Just on that. Perhaps you may go to the second as well, but do not focus on the weakest ones. So make yourself also efficient with regard to that, and you will help probably all the participants in that game. Now, another thing is, if you want to impress your client with all what you know, with all your case law, all your whatever it is, well, that is your game. I will not enter into that. I want you to be successful within the proceedings, and that is my advice. Now let us go a bit on the proceedings. So invalidity applicant files an application for invalidity with the EU IPO. There's a form, it would go through internet, right? Fee is necessary to pay, and he would submit its grounds. Then that would be sent to the design holder. The design holder has a 2 months period to respond to the grounds, and there may be a second round for the invalidity applicant and the design holder in order to present all the facts and arguments. And then a decision will be rendered by the examiner from the design department, and the decision will be sent to both the design holder and validity applicant at the same time. And then it is up to the losing party, so to say, losing party to introduce an appeal if it wants and if it is successful in his point of view. So the appeal, again, through internet, right? It can be introduced after at the latest point 2 months after the publication, the notification of the decision, and the grounds have to be presented 2 months afterward, after this. So it is 2 and 2 months. The first deadline is absolute and the second deadline is relative, meaning that the absolute cannot be extended, but the relative may be extended upon request. So the boards of appeal, they receive the grounds, the notification and the grounds of appeal, and it starts all over again with a ping pong played by EU IPO to the one and to the other, so that everybody has the same information to deal with and to present is facts and arguments with regard to the case. And at the end, the hearing is not something which is being used by EU IPO, so don't ask much for hearing. Hearing would be only necessary if there's something which has to present in person, which rarely is the case. What is it what you can't explain in written proceedings, which need to be present, in order to give it, I don't know, a visual difference with regard to the case. So it is then decided upon the appeal, and the parties are notified at the same time on the decision, and then it can go to the court. The boards of appeal are administrative decision within EU IPO, but they have independent criteria on the ruling. So the president of the office, so to say, of EU IPO would never go to the boards of appeal, to the deciding board, and say, you have to rule on this and you have to rule on that. That is against the regulation. So after boards of appeal, you can go to the court of first instance. That would be in Luxembourg, and there's a second instance court on law only, which would be the court of justice. So these are, so to say, the general proceedings, existing inter partes proceedings that you should know. On the comparison of the signs which each instance will have to go through, if the substance of the case is sufficiently clear from other conditions, would be, we went over this, the informed user, we would go over the designer, the freedom of the designer, and we would go over the overall impression and individual character with regard to the conclusion. Now, a last word is on the individual character. The individual character is something relative, right? You understood this from the previous explanation. So it is stated it has individual character with regard to this proceeding, but that does not mean that you have individual character of that design with regard to other proceedings which may come in the future. So that is always something you have to bear in mind. So I'm a bit over time. Thank you very much for your attention, and hope this was helpful. See you in the next video.